not what we're seeing. And I would really like to get your take. And I know that judges are proactive in the courtroom. And let's say that, a mother doesn't have the resources to get the attorney the representation that she needs, and yet she has evidence coming forward because we do have the divisions of the courts. And so let's say that there is a father who is abusive but has drug charges in criminal court, and then you come forward and the evidence isn't submitted, right, or not, then basically, right, that's where the questions come in, where we, right, want to know, or get your take on the issue, right, as to why you think that's happening.
Okay, a couple things before I forget. One of the things that, depending upon your community, that is helpful is to request the court to appoint an attorney for the child. So again, by protecting
the minors' counsel.
Correct.
Okay.
Now, usually that money comes out of the court budget, so
Okay.
there's a very small amount that's available. Some communities have pro bono counsel,
Right.
that realize how important these issues are, and therefore the family law bar in the community has committed itself that every lawyer will commit to doing 10 hours of pro bono a year where they're not, the court will appoint them in those very difficult child custody cases where there's a lot of emotion and a lot of problems. And then the lawyer is representing the child, so the lawyer will say to the court, my client's the child, based upon this, and this, I think that this ought to happen. My child, if the child is old enough to express an opinion, my client, the child, is of the opinion that he or she should live with this parent for these reasons. And at least by having a lawyer for the child, they're a vehicle for getting information to the court. Now, when you talk about situations where a family or one of the parents of the family has other issues going on, let's say hypothetically, one of the parents has a case in the criminal court, whether it be domestic violence, substance abuse, driving under the influence, something else going on. Well, obviously this information is important, useful, helpful in terms of judicial decision-making with respect to child custody. The court, if they're aware of it, can actually obtain this information on their own. I mean, they need to tell the parties, I'm aware that there's a criminal case involving this parent for this, and I'm requesting my clerk to obtain the file from the criminal division so I can see if there's a probation report, so I can read the police reports, so that I have more information. Now, you have to give the parties notice under fairness principles. So if the parent who is suffering this conviction or adjudication feels that something was unfair, then he or she can address the court and say, look, I take issue with what the probation report is saying in this particular regard, and then the court at least has that feedback and can do other things. Now, if the family is also in dependency court, which is abuse and neglect, there you have a social worker that's done an investigation.
Right.
Now, in terms of getting that report released, that causes additional issues because there's confidentiality issues. But at least if the family court is aware that there's something else, then the family court, in working with the parents, can try to come to some kind of a solution where that information, to the extent that it's useful, is given to the court with the full understanding of the parties. Another court where there could be something else going on is in the probate court in terms of guardianship, and that's investigated by the court's employees that do investigations, and so those reports are not privileged in the same way that they would be in dependency court, and that's information that potentially is helpful because you have an objective person that's going out and obtaining this information. Maybe you need school records. Because one of the things, hypothetically, I like to know is that, if the child has a midweek visit with one of the other parents, and then when the child goes to school on Wednesday or Thursday, if that child is acting up, if that child is having wedding issues, if that child is having performance issues with respect to how they participate in school, and we're talking about younger children, of course, then
Okay.
I want to know that.
We have a caller. I don't want to interrupt you.
No, that's fine.
But we have a caller. Caller, hi. We're
caller.
limiting the calls to about 5 minutes, please, so we can... Can you lower the
Hi,
volume?
good afternoon. This is Lena.
Good
Duval.
afternoon. Good afternoon,
Hello.
Lena.
Actually, thank you so much, Judge Hyman, for giving us your time. I wanted to ask about how can a protective parent trample over Montenegro versus Diaz?
You familiar with Montenegro? No. He's not
Can you guys
familiar.
hear me?
I'm sorry. We can't hear you too well. It's a little broken up. But
Is this better?
I
How
don't.
can a parent trample an
and
order
he's not.
citing Montenegro versus Diaz?
Let me answer that. He's not familiar, and he doesn't want to. He's not familiar with Montenegro
I'm not.
versus Diaz. Unfortunately, it's become a very popular case that is being used to kind of solidify no more coming back into the courts. It's a final order, so to speak, and it seems to be what's being used more and more in the family courts. But because he's
And then
not familiar,
My second question was going to be about proper litigants. There's usually a perception that proper litigants are any arguments they put up before the court that somehow they are any less than, let's say, a flagrant or well-versed attorney. How can let's say, a protective parent who does not have the means to represent themselves, how can they be an effective proper litigant in a family law?
Okay.
That's a very good question, and I think it's one
Thank you.
I think it's one I can help you with. And again, in a very general way. Number one, a lot of counties have help centers. A lot of counties have legal aid that put on lectures in terms of how you can present your case to the court. So what you want to do really is to understand how you get evidence before the court, how you can lawfully, legally get school records, if they're helpful, before the court. They would be business records, and what do you have to do in order to get a record before the court? How do you get medical records, if they're important, before the court? How do you cross-examine people? That's going to be a little bit more difficult. An understanding of what's hearsay, an understanding of how to get criminal records, if important, before the court. These are things that that I think that legal aid and other organizations that put on presentations and help centers can help you with. I don't think that judges, at least I hope that judges, as a general rule, are not prejudiced against people that are representing themselves. Judges are frustrated in the sense that they want to get the information. They want to be careful in terms of how they get the information so there isn't a perception that they are favoring one side over the other. And they want to get it effectively, efficiently, and in a timely way because, unfortunately, they have so many cases and only so much time to do it. But I think that most judges want to do this in a meaningful way, and they want to reach the right decision. And they, but on the other hand, there's only so many ways that they can be helpful in terms of getting this information. So there's a frustration. So I'm sure, and I'm sure I did too when I was there. Occasionally you get frustrated, and occasionally you demonstrate that frustration, which unfortunately sometimes gives the perception to the parties that you don't want them there, which is not the case. And it's very difficult to settle people that are representing themselves because they've heard so much good information, bad information, and they're also a little bit disbelieving in the sense that sometimes they perceive the system as just wanting to get rid of them, and as a result, or what's being suggested to them is what they feel is not in their best interest or the best interest of the children. So there's a lack of trust. One of the biggest things, again, is that the lack of time for judges to be able to spend the time that they would like to. And the second problem is a lack of the financial resources that would allow judges to be able to order the various kinds of assessments that they would like to in terms of having meaningful, helpful information to being able to make better decisions. The end result is that only the worst of the worst cases where there's been all kinds of unfortunate events where they're able to use some of these resources, because in the average kind of case, they don't have it to be able to use. And that's not very satisfying if you're the party that's appearing there and you want the resources used on you. It's a problem. So all that I can say is that to the extent that you're able to get assistance in terms of preparing so that you know what information might be helpful and that you have a game plan in terms of how you lawfully get that information before the trier of fact to assist them in making a better decision.
I hope that answers your question, caller.
Yes, thank you so much.
Good
Thank
luck.
you.
Good luck.
Thank you for calling.
You talk about the time frame that judges have on these cases. What is the time frame, just so our listeners know? What is the time frame for these cases, and how do they go about getting this information in that amount of time?
Well, there isn't a flat rate. In other words, there's short cause and long cause, and the court's rules of court, local rules of court, will determine. Obviously, if you can do your case in 2 hours or less, you're going to get a faster set than if you need 2 days.
Right.
So that is probably the most common kind of question, is in terms of how much time is allotted. Look, if you need several days to present your case, you're going to get several days to present it. It's just that it isn't going to be very quickly in terms of when you get that date. L.A. County, unfortunately, you're going to have to wait longer than you would in Santa Clara County. Santa Clara County, in comparison, is very quick. L.A. County, if you have a civil case, it could take very close to 5 years from the date of the filing for you to be heard. How long is it going to take for your child custody case to be heard? It depends upon actually which part in L.A. you are. Certain parts might be a little bit faster than if you're in downtown. The other thing is there's alternative dispute resolution possibilities. Sometimes you're better off, depending upon what your dispute is, in terms of taking it before a mediator rather than spending the money to litigate it with lawyers. Spend that money on a mediator, arbitrator, and that person will help you get to a resolution, hopefully.
Yeah, there's a couple of things that you brought up. I'm trying to make some mental notes here. Okay. The evaluators. I wanted to touch base for a moment because we hear about these evaluators more and more often. And typically, the parent that is making allegations or saying that these allegations of abuse exist against the child by the other parent, then the courts order this evaluator to help to determine. The problem that we're hearing is unlike what you just said, and I think that you come from a beautiful place, LA obviously is a little different. They don't have a choice in choosing an evaluator. They are literally forced, even at the point of saying, I've done my research on this evaluator, there's a bad track record, there's disciplinary action, there's complaints, what have you. I don't want this evaluator, Your Honor. Please give me the opportunity of somebody with the same credentials of my choosing.
You're talking about a court evaluator?
A court evaluator.
All right. Well, look, you don't get to choose your court evaluator. Okay. You get to choose private evaluators that
well, no, they don't.
For.
They have no choice when it comes to even a 730 evaluator.
Well, you mean the court is appointing the evaluator that the parties are paying for?
Right.
No, they wouldn't.
They do all the time, though. What can the litigants do in this case?
Well, look, and this is time consuming and it's expensive and it's troubling.
$20,000, $50,000, some of these.
It can, sure. No, if you have an evaluator who works for the court that you feel is unfair, then there's a complaint procedure in terms of giving information to supervisors on that side.
Okay.
And maybe even with respect to cross-examination of that evaluator in terms of demonstrating a prejudice. Which is
allowed.
Absolutely.
Yeah.
With respect to the evaluators that work for the court, there's a lot of opportunities to be able to demonstrate, if appropriate, that there's a problem.
Right.
With respect to private evaluators, that's different. Well, similar in the sense that everyone has a license. They're either marriage,
Right.
child, family counselors, they're psychologists,
Right,
they're
PhDs,
social
yeah.
workers. There's all
Sure.
kinds of licenses and degrees, and every license has a board, and complaints can be made to that board. There's also, in terms of cross-examination, where you try to demonstrate before the judge that this
Right.
person isn't fair, and has a prejudice or whatever. That's where you bring these issues up. This is very difficult to do,
Yes.
and sometimes the best thing that you can do in terms of the resources and the like is to be able to demonstrate that the report shouldn't be given any credibility, or should be given less credibility, or that the judge is not required to follow the recommendations. Remember, judges make orders.
Right.
Expert witnesses make recommendations,
Right.
whether it be probation officers, family court service people, probate investigators, social workers in the abuse and neglect system. Everyone makes recommendations. The judge makes orders. The judge is not required to accept those orders. The judge is not required to
accept the recommendations.
Correct. I'm
Okay,
sorry.
that's okay.
Recommendations. Thank you. The judge is not required to accept the testimony. The judge, however, can't, in an abuse of discretion kind of way, just can't be dismissive. The judge needs to consider it, and then if the judge isn't going to follow it, needs to state reasons why. I find that the history that the evaluator has is not accurate. I disagree with the evaluator with respect to this principle or with respect to this conclusion, or because ultimately the judge is the trier of fact. Everybody
Right.
else is just a witness.
That's right.
So, but look, with respect to the family court service person who's an employee of the court, my own personal experience,
Okay.
I probably followed what they recommended 95% of the time.
Okay.
I might tweak it a little bit,
Right.
but by and large, most time I would follow the bulk of what they're recommending. In the criminal court, most of the time I'm going to follow what the probation officer
Right.
recommends, because they're the person that spent the time, that wrote the report, and hopefully
did the footwork.
They did
Yeah.
they did the evaluation. That doesn't mean I'm going to follow it all the time,
Right.
because again, unfortunately, sometimes people take it rather personally when you don't follow recommendations. And most of the time, you're going to follow the recommendation, or at least the bulk of it. And that doesn't mean that that's bad. It just means that you really have to present yourself to these evaluators in the best light possible.
Right.
I'm sorry, we have another caller. I
Okay.
don't mean to cut you off. Caller?
Hello.
Hi, caller. How can we help you today?
Hi, I just wanted to listen if I could.
You want to listen?
Yes.
Please do. You can listen.
Is there a question that you have?
No, I just tuned in a second ago, but I just wanted to listen if I could.
Hi,
Oh, hi,
please do.
perfect.
Yep, you're welcome to listen. You don't need to call to listen. You can just listen online. But we're really glad that you're listening. This is an important show. We hope that you get a lot of
thank you.
valuable information that you can take with you. Thanks for calling.
You're welcome.
Thank you.
Another caller.
Another. Oh, wow.
Hi, caller.
Hi, this is Barry Goldstein. I'm just here a little early.
Hi, Barry. How are you?
Hi, Mr. Goldstein.
Good. Hi.
Barry, well, we're going to take... It's okay to be early. Barry's going to... Yeah, if you can call back, maybe in about another 20 minutes or so. It's about 12:55, about another 20 minutes or so. We have some other callers that are calling, and we want to get some questions, but we're excited to hear what you have to say.
Okay, I'll do that.
Thank you so much,
Thank
Barry.
you. Caller? Hello, caller?
Hi, do we have another caller?
Yes.
Hi, good afternoon.
Hi.
We're limiting the time of callers just so we can take as many in. I know that we're backed up and people, according to the chat room, can't get through. Caller, please go ahead with your question.
Okay. I had a question for Eugene. I wanted to know if when you are in court and you're trying to dispute a 730 report and all the judge is looking at is the 730 report and he's already made his decision, and he's following all the 730 report's recommendations. What can we do?
Well, that's a very tough question because, again, judges are requesting the 730 report to assist the judge in making the decision. So the judge has confidence in that particular person as an expert, or that person would not be an order wouldn't be made to appoint that person as an expert in a certain limited situation. So how do you refute it? By cross-examination and demonstrating that the expert has reached a decision that is not supported by evidence.
We have an attorney who refuses to present any evidence to the contrary. She says she is not able to get the records that we need.
Well, yeah, I'm sorry, I can't give you the specific advice because I don't have all of the information. You could consult with another attorney. That's an option. Obviously, it's a very expensive option. But look, in fairness, when a judge has appointed an expert under 730, then the judge is looking for input because the judge feels that he or she needs this additional information in terms of making a good decision. Once you have that expert's report, then the way to expose any deficiencies is by cross-examination. And absent that, you could, I suppose, have a rebuttal report, but here again it's going to be expensive. I've seen that. If you don't have cross-examination, you could have a rebuttal report. You could even have a rebuttal report in addition to cross-examination. But you need other information to be able to dispute the information that's contained in the expert's report in the 730. Otherwise, the judge is more apt to follow, maybe not 100%, but certainly significantly follow the opinions of that expert. If the judge didn't have confidence in that expert, then the judge would not have appointed that expert.
Okay, this is our third judge, and he's new to the case.
That is a problem. It is a problem in terms of getting multiple judges on cases, and judges try, and the system tries, to the extent that's possible, to keep a family in front of one judge, just for this very reason. I can't,
and we're going to talk about that in a couple of minutes.
It's a problem. I appreciate that. The system appreciates that. When I was in family, judges were appointed to that division for a minimum of 2 years. Now the minimum is 3 years, and judges try very hard to stay with a case from the time that they get there until the time that they leave, for this reason amongst other reasons. But consistency of judges is extremely important, and the system recognizes that. I obviously can't go into why you've had 3 judges in terms of the length of your case and things like that, but you are articulating something that's important, and consistency is important in terms of having one person that's been involved that gets to know the family over a course of time. And it is extremely problematic if you have multiple judges involved in a case.
Okay,
thank you, caller. Thanks for calling. So something that we do want to discuss that is very important is you've done a lot of research on some of the solutions, some of the beautiful solutions, because as we talk about the problems, well, that's fine and dandy. It's depressing. There's no solution. Parents are fleeing, and children are not safe. What can we do to work towards some solution? And you wrote about some of this.
Well, one of them is making sure that the trier of fact, the judge, or the arbitrator, mediator, has all the information. That is the information that other systems, to the extent that the family is in other systems, has been generated, and to make sure that that person understands how to use it. So, for example, the people in the system, so in the criminal you have a probation officer, but that probation officer doesn't really understand the family law system. In an ideal world, they would. In an ideal world, they would understand what evaluators do. Because to a certain extent, in terms of the hierarchy, hypothetically, a criminal judge could make an order that would affect the family court order. Right. In other words, I could, for good reason, I could say in terms of a probation condition, you are not to have any contact with these children unless it's supervised. Maybe the family court order doesn't say that, But as a condition of probation, I'm saying that, well, that's going to trump a family court order because it's a criminal probation condition order.
Right.
But who knows whether or not the judge understands the family court system, except in a really abstract way, whether they understand family court evaluators, whether the judge in criminal really understands child developmental issues, whether the judge really understands domestic violence, whether the judge really understands what happens in the abuse and neglect system, what social workers do, what kind of orders they make, how do you interpret it, understanding what happens in the probate system in terms of those evaluators. And everyone needs to know, number one, about the evidence that's involved in the other systems to the extent that there is, but also needs to know how to actually use that other information.
Right.
And that's another problem.
Is there, so we hear about all these different dynamics in these different courts, and clearly there's a lack of communication, or clearly there's a lack of a database, a sharing of information, if you will. So then when we look at somebody who's just sitting down at the bench for the first time in the family law court, what kind of training do these judges have so that they are able to make educated decisions? You've got some really complex issues that are being brought before them.
Absolutely. And, judges, especially with the economy, I mean, if you're new to family court or any assignment, pretty much you're going to get a 1-week immersion program. So in the case of family law, you're going to be educated with respect to the different kinds of issues you deal with in family court, the different kinds of evidence. You'll have, at least in California, 1 day with an evaluator who's usually a psychologist that talks about these kinds of issues, not to the depth that you would like it, but at least it's more than what you had before.
Right.
And in terms of how you make decisions, and a lot of this stuff is on-the-job training, unfortunately.
Right, it's learn as you go.
To a certain extent.
Right.
And fortunately, if you're interested, there's a lot of stuff that's available online.
But not mandatory.
Not mandatory, no.
Okay.
The course, when you change assignments, it's pretty much mandatory that you need to be
1 week.
Right, and that means whatever assignment.
The 1 week, though, business days we're speaking about, so really it's 5 days, and you've got 1 day with an evaluator.
Right.
How about determining, is there sexual abuse? Because almost on a daily basis, if I had somebody go into a court, family law court, you're probably going to hear one case where there are allegations, whether substantiated or not, of a sexual abuse of a child.
With respect to sexual abuse,
Okay.
usually there's going to be evidence, whether it's going to be police evidence, whether it's going to be forensic evidence with respect to a nurse evaluator or a physician evaluator. There's going to be information from Child Protective Services.
Right.
I would expect, if I were hearing a family law case where there's an allegation of abuse, first of all, it probably will be in the abuse and neglect dependency court. It'll be removed from me until there's an exit order from the dependency court.
Should it be removed from you?
Yes.
It should be. Why is that?
Because they have more resources in the dependency system. Right. For the child, for the parents. Because remember, there's a lot of requirements with respect to federal requirements with respect to reunification. That doesn't mean the parents are living together.
Right.
It means the child is be reunifying with parent or parents, depending upon the circumstances. And there's just a lot more information that's available that can be generated in dependency. There's the mechanism for generating this information in family is, as we've talked about, is extremely limited.
Right.
So that's by law. Now, it'll come back to family when there's an exit order from dependency court. And that exit order is what's referred to as the prima facie order. In other words, that exit order is going to remain the order in terms of child custody. And the only way that the family court can modify that order is on a motion. And again, it's in the best interest of the child standard. Absent that, that remains the order. Now, the reality is, in terms of most situations, Look, 95% of all family law cases resolve. I mean, when you're sitting in family court, you think no one is resolving their case because it's like incoming. I mean, it's like weapons.
Well, you don't hear about those cases.
No, well,
because
no,
they're
you don't see
resolved.
them. You don't
they're,
see
they're
them.
gone.
Right.
They're in, they're out. There's usually no dispute. They're good
Right.
parents. They don't
Right.
like each
Exactly.
other anymore.
Exactly.
They want both parents in the child's
Right.
life.
Right.
They
You're
think
exactly right.
Yeah, and they're leaving, and they don't want to give up
Exactly.
their homes and their bank
Right.
accounts, and
Right.
be in court, and they don't want that for the child.
Right.
The
But
focus.
What about what I'm saying is 95% are resolved cases,
Correct.
but those 5% are
Right.
those are the ones
Take
that
up your time.
Right, they take up the time, but not only that, why are they not being resolved? Because what we're seeing is with a lot of these cases where there is substantiated evidence, where we look at the court file, we read it in black and white, we see the evidence, and you still don't understand why this hasn't been resolved. So it's those 5% that we're fighting for every day. And so that's where my question comes in. When you have preponderance amount of evidence and the child is still with the abuser, I'm just looking at it also with the 5%, but also in my issue, I took legal guardianship of all of my siblings, and so you have minors counsel, you have court 730 eval, you have different people involved, and even after children have stated, this is what's happening in the home, this is what's going on, they're putting me on meds that my sister had to literally lock herself in a car to try to explain to people, I'm not crazy. This woman is abusing me. You need to get me out of here. And this was never noted in the notes. Never was it brought to court after I'm telling the social worker, my sisters are going through this, and that. Nothing was ever documented. And so you look at the situations of all the people involved. What if the child states, I don't trust my minors counsel, I don't feel comfortable, and yet they leave the child with a person that they don't trust, they don't want to speak, they're not going to be vocal, because any foster child, I've lived in the foster care system, I know what it's like. I've went up against DCFS, ultimately won on my own without an attorney. But you look at all these people that are involved and you wonder why these 5% are not being resolved. And could it be because a lot of the people that are within the judicial system are either not educated enough, they're not getting the training that they need, or they are just not listening to the child, which is the utmost importance, is to listen to the child.
Do children have rights? And I mean, we go back to I think
Right.
about the slavery, the time of slavery. I mean, African Americans did not have rights, and that's the way it went. There was this great movement, thank God, and finally they could sit on the same bus. They were human beings. We're all human beings. However, when I look at a child, what they're able to vocalize, what is actually,
Right.
they really don't have a right. I think I look at every child in the same light that the blacks were looked at 50 years ago. You have no rights. Shut your mouth. I don't care what's going on. I'll be the boss.
Well, I certainly understand what you're saying,
Yeah.
and I certainly.
Do they have a voice?
Yes,
Right.
Legally?
yes, they do.
Okay.
Yes, the law has changed in the last couple of years, and the court is required to hear what they have to say.
But why aren't they?
Well, that I can't tell you.
Okay.
Right.
That I can't tell
What
you.
can
but-
we do to make them if they're required?
Right.
I don't have
You
an
don't know.
answer. I can.
Okay.
this is.
But we
one-
can do
Right, right,
something.
no.
This is an area where I don't have an answer.
Okay.
I guess the only thing I can say is that when they're interviewed by various people, they,
Okay.
to the extent that they were able to be assertive, which is
Right.
asking a lot for someone who's certainly
Absolutely.
Right.
been victimized and has
Absolutely.
gone through stuff that we don't even want to think
That's
about.
right.
But the law has recognized the judicial system has recognized, the Judicial Council has recognized in the last couple of years that it's important that children be able to participate to the extent that they are able and want to.
Right.
And the court is supposed to provide for a way for them to be able to do that. Certainly in the dependency system, they participate a great deal more. I mean, they're brought into court.
Right.
First of all, everyone has a lawyer, although this isn't the way it is throughout the United States.
Right.
California, we're very lucky. I mean, depending upon how many children there are, to the extent that their interests are different than other children, you could have children because they're half siblings and stuff like that, where everyone's got a lawyer because everyone has a position that potentially is adverse. And then you have multiple parents because mom has had children with multiple partners. And I'm not being disparaging, but as a result of that, there are issues, and each father might have his own attorney. So you could have a hearing in the dependency system where you've got 6 or 7 lawyers in a room. The social worker has a lawyer, and all of the parties have lawyers, and certainly it's an more informed situation. But getting back, I'm not trying to be evasive, getting back to what your initial comments were, I certainly appreciate what it is that you're saying. I don't know how to answer that question other than to say that the system is required to, and there's more efforts to, and I certainly think it is extremely important that children be able to express themselves. Does that mean that the judge follows their request? No, because the judge has to do what he or she thinks is in the best interest ultimately. And then you have to be concerned about whether or not children have been brainwashed and whether their recollections is accurate and all those. And sometimes children can play games too.
That's right.
So these are extremely difficult decisions, and again, unfortunately, the resources of family court are extremely limited, and as a result, judges are making these extremely difficult decisions.
Do you think the decisions are unintentionally, of course, putting families, especially women and children, in danger at times?
At times, sure. You're only as good as the information that you receive, and if you have insufficient information, then that decreases the level of confidence and ability.
Sure.
And unfortunately, it also decreases the support and the respect that the order should receive from everyone. It's a problem.
Absolutely, it is a problem.
Oh, we have a caller.
Hi, caller.
Hi. How can we help you today?
Let me take your procedure. Hello?
Hello.
Yes.
Hi, how can we help you?
Am I on air?
Yes.
You're on the air right now.
Oh, I was calling because I was listening to your show. I don't know if it's live or not, and you were discussing Facebook and the pedophilias and the various wacko pages out there. And I think you got it a little wrong. What I do know about computers and this government and
what is your
certain
name?
other computer programs is that
I'm
these
sorry.
pages are honeypots and they're being monitored by the government.
Okay. Caller, we're going to limit.
I want your listeners to be aware of that.
Thank you, caller. We appreciate it. We're trying to stay focused right
there
now.
There are other organizations working with the government.
Thank you.
Thank you.
Okay. We really want to stay focused right now, callers, with all due respect to everybody and all issues.
Right.
That we have the Honorable Eugene here for a little while. I call him Honorable because any person who is honorable should be called honorable. So we know he's retired, a retired judge, just to let all the listeners out there know.
I really want to talk about the direction of, the divisions of the court system, which I love your direction in the intercourt communications, which I think in Santa Clara, which I read in your article, was Rule 11 in Santa Clara, and just how intercourt communication helped the judicial system there, because I think that is a key component as to why a lot of these issues are not resolved, is because one, there's so many cases coming forward, and then that there isn't communication between each courtroom, each division. Oh, go ahead.
Sorry.
No
I'm
worries.
sorry.
Caller?
Yes, this is Barry.
Hi, Barry. How are you today?
Good.
So, Barry, I want to introduce you to Eugene Hyman. Eugene Hyman.
We've met.
You have met?
Oh, yeah, sure.
Oh, okay.
Yes,
Okay,
sure.
so great. Okay, so let's. I don't know. Was there some discussions? Let's chat a bit. Eugene was starting to. Priscilla was.
Well, I just
finishing.
I really like the direction that Honorable Judge, Hyman is talking about inter-court communication, because a lot of the issues as to why a lot of these cases aren't resolved is because there is limited information. It's contextualized,
That is shared.
right? Just to share information, and from what I'm getting, it's basically one judge with one family, so that way they.
No, ideally it would be one.
That's what he wants.
Ideally, that would be in a perfect world. To be able to hear a family's case, but I think it is, the right direction. If you guys can elaborate a little bit more on your thoughts as to the direction of where Judge Hyman is.
Again, the problem is that where parties are unrepresented in family court, then they may not know what's important in terms of decision making and what the judge would want to know, in which case the judge might say, are you in other divisions of the court? Some judges feel comfortable doing that. I did. Some judges may not. I felt comfortable once I found out they were in other divisions to try and get information from those other divisions,
Right.
make sure I shared that information with the parties so that people could disagree with the information to the extent that they wanted to. But in an ideal world, if they had attorneys, they would be obtaining the information and they would be giving it to me. I noticed, though, when I was in criminal court, one of the things that was surprising were you do have lawyers, you do have a prosecutor and you have a defense attorney, and even then I didn't necessarily get information. I might say, well, gee, is this family in other divisions? Is there a family law action going on? Is there a dependency? Is there a probate matter going on with other evidence? Well, gee, we don't know. Well, why don't we ask the parties, ask the defendant, Mr. Defense Attorney, and find out, so that, because if there is other information, I want to have it. It'll be helpful in terms of maybe adjudicating this dispute. So even the lawyers don't necessarily obtain it when there are lawyers. So there needs to be a culture shift where everyone says, hey, this all information is valuable. Decisions can only be made good decisions to the extent that there is information sharing and available. And unfortunately, depending upon the court, sometimes court systems and databases aren't easily set up in such a way that information sharing. For years and years, the abuse and neglect system purposefully had a separate database so that information wouldn't be disclosed. Same thing with juvenile delinquency, and then with the other divisions. So this information was firewalled in such a way that it wouldn't be disclosed inappropriately. And I certainly understand that and respect that. But when we talk about decision making with respect to children's and family court and other kinds of environments where children come up, we need to have this information in terms of making good decisions. And there needs to be a way to exchange it.
Barry, what is your take on this?
Well, I did have an opportunity to practice in New York in some of the integrated domestic violence courts, and I thought it was a good system, and I had a chance to read Judge Hyman's article, and I thought it was a good idea. One of the things I found particularly interesting in my research for the Quincy model, that in Massachusetts, they have an interesting system where a defendant's history, including juvenile offenses, orders of protection, including things that were later satisfied or removed, that record was available for judges, and it was particularly helpful in the case of domestic violence because men abuse women based on a belief system, and too often we see in family court that the assumption is if the relationship is over, then he's not a risk anymore. But his belief system didn't change, and very often abusers will mistreat one victim after another. So if we place children with an abuser, they're likely to see him abuse the next partner,
Right.
and we don't adequately consider that.
I agree.
Yeah, something.
No
that-
disagreement here.
Yeah, absolutely. Well, something that you were saying, Eugene, that I just absolutely loved. We had our hands up in the air. Was looking at the three parties: dad, mom, and child. Would you discuss that a little bit
Sure.
again?
Again, it's my premise that if you keep children safe, then you keep usually the victim, the person that they're living with, safe. And while there's a tendency for people to victim blame, I don't mean just domestic violence.
Right.
I mean, they victim blame whenever there's a victim. It's like, what were you doing in this dark alley? Why were you carrying so much money? Rather than saying, hey, look, you ought to be able to do
Why is
things.
your skirt so short? You know?
Why can't you just be safe?
Yeah.
I have yet to meet anyone that would blame a child for what happens with respect to their parents. So my center and what I advocate is keeping children safe. If you keep
Right.
children safe, then you keep adults safe.
Right.
I love that.
And that's the orientation. I think that's the better way to go. So you don't have the victim blaming kind of thing, and you set up systems for keeping children safe, and with respect to restraining orders, protection orders, and with respect to visitation, with respect to custody access, with respect to child support. See, one of the things I advocate with respect to domestic violence in the criminal court is that the court needs to say, hey, look, you have to support your child. And if there's a support order, and if you're not paying that support order, then you're in violation of your probation, because one of the orders of probation is obey all laws. And if you have a lawful order saying that you have to pay your support, unless you have injuries or illness or something like that and you can't work, then you need to be out there trying to get a job supporting your child.
Right.
Because the literature is clear. Children that are not supported are at risk in terms of bad outcomes. And it makes common sense.
I mean, does the woman typically leave the first time she's been beat?
No.
Let's think.
Many times. And here's the other problem, though, that's presented, and I certainly understand this. A lot of women do not pursue support, whether it be for themselves or whether it be for their children, because they're concerned that if they do, then the batterer will not just find them, but will be insistent on visitations. Hey, if I'm going to pay for the kid, then I'm going to want to spend time with them. And it's a control thing.
Yeah.
And so they don't insist on spousal support a lot of times. They don't insist on child support because they want that particular abuser out of the way, out of the life. And if that person is in fact paying, then that increases the likelihood that person will be participating and in a negative way. But what I'm saying, though, however, is that if the person is on probation, and I certainly understand that the criminal system has a hammer that the family law system doesn't have, and that's to the extent that it's available is the county jail or a state prison, depending on whether it's a felony or a misdemeanor. Now, there is a problem with respect to your large counties, for example, Los Angeles, where if you are sentenced to jail, you're going to do very little time because there's no room at the inn.
Right.
This is where policy is extremely important, because the judges need to work out with the sheriff in terms of saying, hey, certain kinds of crime you don't release. Domestic violence, people that are doing time for domestic violence, you don't release. If you're going to release people for driving on a suspended driver's license because they haven't paid their tickets,
come on,
that's one thing.
That's right.
But for sex offenses, violence offenses, those people don't get released.
No shortening of time.
No shortening of time. They don't get released.
That's right.
But again, these are policy decisions, and I appreciate when that there's been various kinds of celebrities and the like that are given jail, and they do very little of it because the jails are full, and I understand. But when we're talking about, well, even drug treatment courts with respect to the need to custody, they have arrangements with the county jail where they have therapeutic jailing, where people will actually be able to be kept for a couple of weeks and they won't be released because it's an important part of their therapeutic intervention with respect to the drug treatment court. And if they're doing it there, they need to do it in other areas as well.
Right. We've got several people on that say, they go for protective orders, they get the TRO, and they eventually go for the restraining order. And it might as well just be a piece of paper that they found on the side of the road. They're not enforced.
So you're saying that law enforcement is not honoring them?
Is not honoring them. They're not being protected, and then they feel more endangered because now.
Yes. Well, clearly,
Yeah.
if you have a protection order that is not being enforced, then the person potentially is at greater risk than if they
Right.
didn't have it.
At all.
Because now the batterer is all upset because they've gone to court and they've gotten this order and they've been what they perceive to be inconvenienced and embarrassed and everything else. Look, if you have a protection order which is criminal or a restraining order which is civil, then if you call the police and if they're not honoring it, then something needs to happen. Because it's
What could that be?
Well, there needs to be the advocates, I suppose, need to become involved with respect to the police agencies and find out why the court's lawful order. And the court, to a certain extent, can say, hey, we're receiving information that our orders are not being honored.
Right.
Why not?
Right.
Because judges take great umbrage when a court order is being
They put an order that's flagrantly being
so
disrespected.
I can't, with respect to the people that are responding online and saying that their orders aren't being followed.
Be careful. Be careful.
There needs to contact domestic violence agencies, advocacy agencies, and find out what they can do to assist you in having. I mean, I'm a bit confused. I mean, technically, what I'm used to in my community is that they call up the police and say, "Hey, this person is here, and I have an order of protection, or I have a restraining order prohibiting them.
It's
being
right
violated."
now.
Well, in the police agencies in my county, that's a high priority call. They come out, and if the person's gone, they go looking for them because that doesn't have to be committed in their presence. They're able to arrest them because domestic violence related offenses do not have to be committed, even misdemeanors, be committed in the presence of a police officer for the police officer to take action. And the other thing is that these orders are given priority with respect to enforcement. So I don't know if you're living in a community where you call the police and they don't come out, you need to go to domestic violence agency because they have relationships usually with local police departments and sheriff's offices, substations, and find out why exactly this is happening.
Barry, Barry, I hope you're still with us.
Yes.
Wonderful. Okay, we'd love to hear your input.
Well, my input often has to do with what the research says. And so when you're talking about orders of protection, certainly there are times that it's not enforced the way it should. Mm-hmm. But in general, a victim is safer with a protective order than without a protective order. And, lots of times it might be an individual police officer who, is an abuser himself or, doesn't think much about the importance of domestic violence. Sometimes getting a different police officer or going to a higher authority might be helpful.
Right.
And another piece of research I want to mention, and I think it very much supports what the judge was saying, is that the only things that have been shown to change abuser behavior are accountability and monitoring. So putting them in jail is really helpful because it sends a message that society no longer tolerates that kind of behavior because we have a long history of allowing it. And so I agree that it's important to put abusers in jail if the laws and if their offense allows that, but the strictest enforcement is the best way to get their attention.
Absolutely. Mm-hmm. Something that you've touched on, Barry, that I'm familiar with, that eats at so many people is when you have allegations of abuse with a child, it should, and it's substantiated, say sexual. I hate to keep going back there, because I don't want this to be the only focus, but this is such an issue in America right now and in the world. Shouldn't it be handled? It should be handled, not shouldn't it? It should be handled criminally because that's criminal molestation, child molestation is criminal, period. However, it's handled differently, and you've touched base on that. Would you share that with us, how the process is handled based on if it's familial versus stranger danger?
I am really looking forward to publishing my next book with Dr. Hanna, because we have a chapter by Camille Cooper from the organization
I'm
called
familiar
Protect
with her. Yeah.
that is really helpful, and it talks about what you were saying, that when a child is allegedly sexually abused by a stranger, the police take the lead, they investigate aggressively, they try to get evidence, and they're trying to make a criminal case and put the offender in jail. But when the alleged offender is someone the child knows, particularly a close relative, the lead investigator is a social worker. They will give notice to both parents, which allows for the child to be silenced and any evidence to be destroyed.
Mm-hmm.
They look to reunify the child with the sexual offender. They're not looking to gather evidence. And then if later the case becomes a custody case, the lack of evidence is seen as proof that the mother made up the allegations rather than that it was never properly investigated. And the result is that even though deliberately false allegations of sexual abuse made by mothers is extremely rare, less than 2% of the time, in 85% of cases involving allegations of child sexual abuse, the alleged abuser gets custody, which means we're sending a lot of children to live with their rapists.
Right. What, Eugene?
Well, no, I totally agree with everything that Barry has said. And it isn't just with respect to children. It's also stranger rape is treated differently than acquaintance rape.
Even though it's the same exact
it's the same crime. Well, partly we don't want to believe that this is happening from caregivers.
Do you think that that's what it is?
That's partly it. I mean, it's partly with respect to domestic violence. We don't want to believe that people that are in intimate relationships are hurting one another. It's against our basic belief system.
Course.
We don't want to believe that people are hurting animals.
Right.
But that said, we know that, unfortunately, that there are people. The other unfortunate thing is that there's this universal belief that with respect to family issues, that the privacy, that it's the family.
Absolutely. What happens behind these doors, right? That's how we were.
It's like what happens in Vegas stays in
Vegas.
Bet. Right. and partly also with respect to the church, this is something that the church should work out. This isn't something that the criminal justice system should be involved in, or even the civil system should be involved in, because this is just so painful for us to deal with. And then there's also the belief above and beyond that is if it's so bad, why did she stay? And then with respect to the child issue is that parents are manipulating children, and you can't really a lot of times believe what a child is saying because they're being manipulated by parents to make them happy, and that certainly occurs, but not at the rate at which
they've got 98% that these disclosures are accurate. I mean, logically, it's impossible for a 5-year-old to go through such a detail.
Exactly. I totally agree.
Yeah.
And then again, it's also a resource issue in terms of where we spend the limited resources that we have, and this is not, unfortunately, where we're necessarily spending our money. Now, these cases get preference. So when you
by whom?
By the courts. I mean, in terms of when courts are closing doors or whatever, they can delay civil cases for up to 5 years, but there are strict timelines with respect to other kinds of cases, speedy trial rights, with respect to the criminal cases, with respect to dependency cases. When you've taken a child away, hearings have to be held within straight time limits. Family law matters, they've got what's called emergency screenings, where you're alleging that children are at risk, in which case, there I would take a two-pronged approach. Now, you would go ahead and move in terms of, by motion, in terms of the family court to request a screening. At the same time, I would contact Child Protective Services, and because once they intervene, to the extent once something is filed, then the family court's jurisdiction is removed. But until then, it's sort of a race to the courthouse to see which system is going to do something.
Right.
Now, interestingly enough, a lot of times, if the family court is doing something, that is, if the family court is intervening, then sometimes Child Protective Services doesn't want to become involved. Their concern is, well, they're doing something, they're actively looking into it, we're content. Again, this is a local cultural issue in terms of how the different systems intervene. So in some communities, if family court's involved, then the child protective system won't become involved unless the family court doesn't do anything and they have information that in fact abuse is occurring, then they might do something. So it's, again, dollars and cents to a certain extent motivate people in terms of what they do.
Yes.
Right.
Do you think, Barry, I know that you're always pushing for change and just to get this system to where the children are protected.
And where the where
Yeah.
they become priority.
Eugene is definitely saying, you know what, mom or the person being abused may go back several times. This is the cycle in many instances.
Oh, absolutely.
Unfortunately. However, if the focus were at the child or children, it may be viewed differently, and ultimately the result may be different.
Well, I hope so, but not necessarily.
Right, but we haven't tried it.
Right.
We haven't tried it. We have tried a lot of other approaches that are
Right.
clearly not working, so it's almost a process of elimination, if you
Right.
will. Barry,
Yes.
I don't know. Do you have anything to add?
Yeah. No, I was interested in what the judge was saying before about keeping children safe, because, Tammy, you and I have talked a lot about my proposal, which is a Safe Child Act, which basically says that when courts are determining the best interest of the child, they should be required to consider the child's safety as the first consideration, and before they go to any of the other factors,
The best
which are far
interest standards. Yeah.
safety.
Well, I would argue that the child's safety is part of the best interest.
But it's not. I mean, I
It's
would
supposed to
disagree.
be.
It's supposed to be
it's supposed to-
100%. However, I don't even
That's not
think
the way it's applied. in
Right.
our
It doesn't. It
courtrooms.
doesn't appear anyway. At the very least, it doesn't appear. What it does appear to be is some of the topics that you brought up, Eugene, with all respect.
Well, again, how things are done, 58 counties,
Right.
not necessarily 58,
Absolutely.
not necessally
Right.
58 different ways of doing things, but certainly different ways of
Fluctuations.
and then you got judicial changes amongst them between, and or deferring, and again, in terms of the court's expert, most of the time it's going to be family court services in the case of family, or
Right.
in the case of abuse, neglect, dependency, it's going to be the social worker. And not that judges aren't independent and don't disagree or whatever. I mean, sometimes a judge is going to return a child
Right.
over the objection of county counsel who's representing Child Protective Services, and it does happen. And it might be the appropriate thing, given from the findings that the judge makes. Is a judge going to occasionally make findings that are not correct? Absolutely.
Well, I mean, they're human beings, and
Sure.
we've discussed that too. Nobody's going to be perfect in any entity. CPS, we see their failures. They are great.
Now, what's interesting with respect to one of the judges, that's the presiding judge over the dependency system in Los Angeles County, interestingly enough, is a proponent for opening up the dependency courts. So
Judge
that,
Nash,
correct.
fabulous. We
Yes.
are.
People are fighting him on that.
Yeah, you know what? We'll stand behind Judge Nash's decision. We were part of watching this.
No, he's
transpire.
a big proponent.
Yes, he is.
And I've met Judge Nash on a couple of occasions. I have a
Yes.
great deal of respect for him.
Yes.
He's certainly a person who's
And he's pushing for it.
He's very dedicated
Yes.
to helping children in Los Angeles County, and there's ways of protecting identity, and just
That's
because
right.
it's an open courtroom doesn't mean that the names get discussed
That's
or the
right.
names get revealed.
I think that's an
But-
excuse.
But there's accountability, and when you have openness, you have greater accountability. And
That's right.
And he is saying, and of course he's being the people that are fighting him are, for the most part, governmental departments.
Right.
And there are some people that have been through the system as children that are now
Right.
adults that are fighting it as well,
Right.
on a belief that this is not good for foster children or for children who are dependents of the court. And I think that they're sincere in terms of their beliefs. But this is something that's playing out. Ultimately, I think there'll be legislation which will give a lot more discretion.
We stand behind Judge Nash on that. He did a great interview with Martin Burns, with children lost in the series system, and he said, in a nutshell, we have 6 minutes to go through this entire case. It's extremely hard to get it right, and he then went on to say he'd like to open up the doors. It will help. And
I think it will.
we need to stand behind him.
Yes.
We need to find out how we can in a little more of an assertive way. Barry, we have a caller. We have another caller. Okay, go ahead, caller.
Yes, hi. It's a little off topic. This is Melissa from the Safe Child Task Force.
Hi, Melissa.
Hi.
Can you lower down the volume?
Sure, I just put it down.
Thank you.
Yes, I did.
Hi.
So I'm calling because, we've been following the SOL reform movement across the country, and today our SOL SB 131 won today.
Thank
Yay.
you.
California.
Thank you. This
Yeah.
is beautiful news. SB 131. Yay.
Yay, really
This is
excited
great.
with that.
Amazing
This
news.
exceeds
Amazing news
the
for our victims.
Statute of limitation
Right.
for victims of abuse by clergy. Sexual.
Very happy.
Excellent,
Very
Melissa.
happy.
I'm so
Thank you so much, Melissa.
pleased.
Yes, well, thank you, everyone, for supporting SB 131. It's a big victory for the advocates, for the victims of child abuse. We're getting it so
Yes.
long at Family and Dependency Court. The very
Yes.
least we can do is provide for those adults
That's right.
when they age out,
That's
and when
right.
they are able to come to terms with their abuse, to be able to sue
They
civilly.
didn't get any
And,
justice, and it's
Right,
damned
they didn't
well
get
that
justice.
they have rights, and their rights were not recognized. But we shouldn't say it's too late for you to find the courage to step up and be able to now have rights if you so desire.
Absolutely. There is another part to this, and that is
Okay.
it allows us to get the pedophiles off the street. Honestly, if we can open up the documents, evidentiary hearings to be able to present in civil court proceedings, we then have evidence to take into criminal courts when there is, when then allegations come up. And we can begin to identify those pedophiles. I mean, honestly, with every pedophile out there unidentified, we have hundreds of victims. And everything that we can do to get them off the street and to support our victims.
Yeah.
We have victims who will never be able to come forward. And so...
Well, we're pushing
in
for
that
them.
name-
We're pushing
Yeah.
to give them the encouragement that's needed. Thank you, Melissa.
Thank you, Melissa.
Thank you so much.
Thank
and
you
I'll
so
post some
much.
information on the chat room. We won by
Thank
42 votes.
Oh my gosh.
15.
This
yeah,
is
15
what
voted
unity
no.
and coming together with
Yep.
one mind. This is the result. If only we could do this with so many other issues.
Yes, thank you, National Safe Child Show.
Thank
Yeah,
you,
thank you.
Melissa. We love you.
Thank you.
Mhm.
All right, thank you.
Barry,
Yes.
this is a great victory. I don't know if you're
Yes.
familiar. Yeah, this is a great victory. So, okay. So getting back to Eugene, where do we go from here? What do we want to see happen? And because we're going to push for it. So let's make a list. Okay, here's our priority list. We're not going to say something unrealistic. We are dreamers and visionaries. However, we are fighters, And we're realistic people with realistic goals. What's the first goal?
Well, I think an exchange of information. I think
Okay.
information ought to be available to judges in all divisions of the court and
Okay.
to the parties, so that better information, better decision making, and there needs to be more resources and needs to be more evaluators.
Resources as far as what?
Well, in terms of family court evaluators, there needs to be more of them. They need to be available for emergency screenings, which are, as the name suggests, emergency situations.
Yes.
In terms of things that come up, rather than matters being referred to the dependency court, family court, or if the family's in family court, they ought to be able to adjudicate on an emergency basis with information, and there needs to be availability of child attorneys. Again, not every child needs an attorney, but those that are in the worst kinds of cases where there's the most heated battles between parents, then this is more likely to ensure that a child's voice is heard.
Yes, absolutely. Barry, what is on the top of your priority wish list?
There's something I want to talk about, and I hope I can get some a response from the judge. I am really excited about some of the new medical research that talks about the health impact on children of domestic violence, child abuse, and other trauma, and the fact that once they've been abused, more abuse or witnessing more abuse multiplies the risk. And the findings are that children who witness domestic violence will suffer more illnesses and injuries as children and then later as adults, and their life expectancy is reduced,
Absolutely.
which is a huge consideration. And I find that when we try to approach the court systems, they tend to be satisfied with what they're doing, even though I think the research wouldn't support that. So what I really want to ask the judge is there a way that we can take this new medical research, which I don't think would be considered controversial, some of it comes from the CDC, for instance, and encourage the court system to sit down with the medical researchers, with domestic violence advocates, with researchers, to figure out if there's a way we can change how the court responds to domestic violence and child abuse cases, with an emphasis on safety of the children, and based on this new research, which I think makes it critical that we protect the children.
We have
this
3 minutes. We have 3 minutes left.
Right.
I want.
First of all, I totally agree with Barry in terms of these concerns.
Okay.
In terms of dealing with them from a court perspective, I guess would be to change the rules of court to make sure that judges consider specifically certain kinds of things, maybe more rebuttable presumptions,
Okay.
legislative changes,
Okay.
because part of the legislative process is that the legislators hear from the judges through their association in terms of tweaking legislation, so that it isn't just them passing legislation that judges have to follow without the judge association having some input.
Right.
So I'm all in favor of mandatory legislation, because then that way the judges have to address it in their judgments in terms of if there's certain kinds of findings, then they have to make findings consistent with the evidence.
That's right. We have some people working with us, Barry, Priscilla and myself, and National, and we're going to take Eugene's hand, and we're taking him to Washington when all is said and done, because he's going to help us fight to make these changes that will ultimately not only change society, they're going to change. It's just going to change the future. Our grandchildren will be able to live in a safer environment as a result of things that have to be changed. This system can't go on the way it has. Clearly,
I think both Mr. Hyman and Barry have really good direction
Great direction.
Great direction. And I think that it's just basically implementing and taking charge. And I know that we're going to get there because we're fighters.
Yes.
We're assertive, we're aggressive, we're there. And so
Yes.
we're just very happy. We're very, very happy that you guys are in the right direction that we want, which is basically transparency, accountability, and ultimately just to make children safety and protection of all children.
We need our children to be safe. We owe that to them.
Exactly.
Last words. We are so honored. I could have gone on 2 more hours with you.
Well, thank you.
Yeah,
Thank you.
honestly.
I hope this was helpful.
Oh, this
It was
is
very
more than helpful.
Very
It's,
helpful.
it's definitely
Well, you
not.
can't give up. I mean, we can't
No.
give up. Children
We-
are too important. We can't give up.
That's
Exactly.
right.
And
That's
and the
right.
safety of victims.
And with people like you and people like you, Barry, who, you know, we adore all the work that you're doing. Both of you gentlemen, you are just champions, along with Martin. I
Yes.
want to always bring up Martin, that I miss so much, who was also a champion in this. And with gentlemen like you and wonderful women who are in the forefront of this, it's impossible not to see victory for the sake of the children. We honor you so very much.
Well, thank you again for inviting me.
Yeah, it is our pleasure.
And
Thank you,
welcome to
Barry.
the ride, both of you.
Yeah, and don't worry, we're locking the doors, so don't
Right.
bother trying to escape. We won't let you. Okay, we thank you, listeners,
Thank you.
for participating.
And we are dedicating the show
Yes.
to baby Matthew Vandergrift today. We always dedicate our show to a child. So, baby
Yes.
Matthew, this one's for you.
Excellent. Bye, listeners.
Bye.
Thank you for listening to the National Safe Child Show on UBN Radio. For past episodes, visit the archives on ubnradio.com. And for more information, go to nationalsafechildcoalition.com.
Now that you've found UBN Radio and discovered our quality talk shows, it's time to spread the word to friends, family, and the universe. 24 hours of music and talk. Radio without limits. That's why people keep coming back for more. That's ubnradio.com.
Hey listeners, are you interested in animals great and small? Do you want to help preserve, conserve, and protect with love, dignity, and respect? Then you are going to want to tune in to Animal Magnetism with your host, that's me, Carolyn Hennessy, every other Sunday at 10 a.m. in the morning. A great way to wake up. Check the UBN radio calendar for the schedule. Talk at you then.